Hello, everybody. Good evening. This is 5:30 or 5:32 p.m. here in India. And, all of you from India and other countries, we're delighted to have you with us. Today, the topic that Nishith Desai Associates has invited speakers for is tax indemnities and other tax considerations. And before we start, we will take a short amount of time, and I would like to introduce the firm as well as our speakers. So, Nishith Desai Associates is a research and strategy-driven international firm with offices in Mumbai, Palo Alto, Silicon Valley, Bangalore, Singapore, New Delhi, Munich, and New York. Its team comprises of specialists who provide strategic advice on legal, regulatory, and tax-related matters in an integrated manner derived from key insights carefully culled from allied industries. Nishith Desai pioneered the field of international taxation and asset management industry. NDA advised Mauritius and more recently helped conceptualize the Gift City financial centers. Nishith Desai Associates has engaged in private equity for over 3 decades and is a thought leader in private equity and legal matters relating to several other areas, including technology. Nishith Desai Associates has remained in the forefront of advances in these fields and has been awarded the Asia's Most Innovative Law Firm Award by the Financial Times for 4 years in a row. Given NDA's deep involvement in private equity, it provides invaluable insights for the benefit of its clients, the ecosystem, as well as the regulators. Many of these insights are published regularly and can be accessed via Nishith Desai Associates' newsletters and special reports available on NDA's website. Now I'll turn over to our esteemed guests today. We have Harshal Kamdar. He is a chartered accountant, and according to the website, he's part of the high energy, high performance, infectiously positive team of Sequoia and its family of founders. As the CFO for Southeast Asia and India, Harshal helps startups with restructuring, regulations, and tax across jurisdictions, transactions including M&A, IPO, and financial matters. Another guest today is Ruthvik Doshi. He's the managing director and general partner at Indemnities Capital India. Ruthvik has participated in India's fast emerging internet ecosystem since 2007, first with Google, where he launched several products. And he was most recently the CEO of e-commerce startup Taggle in Bangalore. Before Google, he spent 6 years in the US building internet management software for CA Technologies and a startup. He's a BTech from IIT Kharagpur and an MBA from INSEAD, France. Interestingly, he holds 6 patents. Ms. Parul Jain of Nishith Desai Associates co-heads the international tax and fund formation practices at Nishith Desai Associates. She focuses on international taxation, cross-border transactions, and fund formation practice, including cross-border investments. She is adept in advising on cross-border issues arising from investments into India. She has represented several prominent private equity, venture capital, growth, and angel funds in setting up their offshore and onshore fund structures. She has also worked with technology companies on digital taxation. She also formed part of a 4-member committee which advised SEBI on changes to be brought to angel fund regulations in India. Finally, we have Ashish Sodhani, also of Nishith Desai Associates. He's a leader of the International Tax Practice Group at the multi-skilled and strategy-driven international law firm Nishith Desai Associates. He focuses on cross-border tax and corporate structuring transactions, including tax litigation, tax treaty, interpretation, etc. He also acted and advised on several cross-border mergers and acquisitions and has significant experience in private equity investing. He has also been involved in regularly advising the gaming industry, BPOs, healthcare, and ITES with respect to issues on withholding tax, goods and services tax. So at this point, I would also like to make an announcement. This event or this discussion will continue until 6:30 p.m. And after that, we will have what is called a coffee corner. All the participants are welcome to join the coffee corner as well. This event will automatically transform itself into the coffee corner, or there would be an area that you can click near the chat box and enter the coffee corner. So at this point, I'd like to hand over to Harshal Kamdar of Sequoia Capital, who will moderate the rest of the session.
Thank you so much, Arvind. Thank you. I wish I have the energy and enthusiasm, maybe your age. Thank you, Arvind. We've seen you, being so they say like only taxes and death are certain, but taxes get worse every year. So gentlemen and ladies, we have arguably the best tax lawyers in this region, which is Parul and Ashish. We have both the sides of the table, the investor, which is Ruthvik, who is a general partner at Indemnities, and the traffic police, the brake master, the CFO, the people putting the brake on, that is me. So without much ado, I'm going to ask, dive straight in. Maybe I'll lean on and start with Ruthvik. Let's just zoom out, Ruthvik, before we dive into the tax puzzle. Is how important or critical, purely from a value standpoint, because I mean, tax is going to be 10.92, maybe for residents 20%, but from a time spent versus deal making versus tax perspective, how much of the effort and time gets spent on negotiating the tax part of the deal?
Harshal, I think you've touched upon one of the most sensitive parts of the whole transaction process. Usually, when you look at the venture capital space, there seems to be a lot of importance that is placed to speed of deal making, and that has evidently played out at least at the time of making new investments. So if you look at what has happened in the last 5 years, new investments today, speed is important. Speed is what makes you competitive in the market, and all of us have implemented it. But unfortunately, the same situation is not present at the time of exits. At the time of an exit, speed is important because both the buyer and the company which is being bought, for them, closing the transaction is important. But we've seen several M&As which stretch from anywhere between 4 months to 6 months. And unfortunately, 50 to 60% of the time gets spent in just figuring out what is the right taxation rule that needs to be applied and how do you compute the right tax over there. Even though you kind of mentioned that, it's 10.92% and 20%, on paper, yes, it does sound as simplistic as that. Unfortunately, there's so many nuances around that, and there's so many interpretations of those tax rules that it takes an army of lawyers, an army of accountants from all the big four firms involved in every transaction to figure out what the right amounts are and who should do what. And in every M&A, till the last day, everybody's unsure what the right thing is. So okay. Yes, this has been a big burning issue.
So you make the tax advisors, including me in my prior avatar, sound like the Hindi movie police that that would arrive at the scene till the last minute. But Ashish, Parul, let me make this, indulge me and make this easy for us to understand. If you could walk through the history of maybe the last 20 years, right, which has been at least a couple of generations in the history of deal making for private equity and venture capital, and how have we evolved from being a simplistic regime to having a piece of paper and getting a tax benefit, to the details, to the nuance, and to deal making, to indirect transfer, to Hutchison Vodafone, to the tax treaty getting killed. Walk us through the history, literally from when Nishith Desai started this practice, Mauritius, when Mauritius began, to literally where we are now. I mean, I can say we are almost crossing teenage and jumping into naive adolescence. But over to you, Parul.
Yeah, sure. Thanks, Arshad. So I think if we talk about the history, and of course, the Mauritius route was discovered by Mr. Nishith Desai, a few decades ago. Since then, Mauritius has been the favored route for investment into India, and India and Mauritius had signed a tax treaty. We have gone through the entire motions with respect to various rulings on treaty shopping, judicial anti-avoidance, and so on and so forth. But finally, it was the Azadi Bachao Andolan ruling which really, hit the nail in the coffin and said that treaty shopping is legal. This actually then paved the way for, figuring out how Mauritius structures should be set up. And, the circular issued by the government of India stating that a tax residency certificate is proof of residency and beneficial ownership. Even today, that is the law. The law is that if a Mauritius entity has a valid TRC, then it is protected by the circular read along with the Azadi Bachao Andolan Supreme Court ruling. So that's the legal position, and nothing can as such disturb it. Of course, fast forward many years, 2017 came, and of course, indirect transfer is a different saga, which Ashish will talk about. But 2017, the treaties were negotiated, renegotiated. The Mauritius, Singapore, Cyprus treaties were then changed to provide for, grandfathering of the existing investments till 31st March 2017, and tax only on investments made after 1st April 2017. This was actually the turning point, and where people felt that okay, now this actually brings about a lot of certainty. So of course, if a private equity investor is holding shares prior to 2017, that's fine. Then you should get the treaty benefit. And it's after 1st April 2017, then you pay the tax. So in the investor's mind, this brought about some sort of a certainty. But unfortunately, then what happened is that the questions with respect to is grandfathering of shares, sacrosanct? Do you get treaty benefits just because the investment is grandfathered, or do you need to satisfy other tests? For example, do you need to satisfy any sort of inbuilt substance test, judicial anti-avoidance? Is the TRC good enough? I think because of the uncertainty around some of these aspects, and also given that tax authorities have looked at some of the transactions, of course, some transactions have had their bad facts. So not to really put the entire blame on the revenue, but some transactions have had their bad facts. And in some of the transactions, it's more about their high value transactions that have been reported out in the newspapers, and tax authorities want to check what's really happening there. So post 2017, of course, GAR also came around the same time. But again, transactions made prior to 1st April 2017 have been grandfathered from GAR as well. We've not really seen any cases surrounding GAR, but treaty eligibility still remains to be a sticky question, more with respect to, are you really eligible for tax treaty benefits, even if you're holding just a TRC? Who's really making the decisions in Mauritius? Do you have an apt board? Is it a capable board? Is the board just a rubber stamping board? On the flip side, Mauritius has also revamped a lot of its, in its bid to get into the whitelist. It has revamped a lot of its KYC norms and its, substance requirements on who can really be the decision-making person or the Mauritius entity. So I think it's because of these issues that even today, when we are sitting in 2022, shares held till 2017, while they are grandfathered, but there is still this sticky issue with respect to whether tax needs to be paid. And hence the negotiations around the tax indemnities, the 197 certificates, the 281s, and along with it, also comes, tax insurance. One interesting aspect about, Mauritius grandfathering is that while, equity shares are grandfathered, but if CCPS is subsequently converted into equity shares, then those equity shares are not grandfathered. So I think a lot of people don't even realize that, that's when tax advisors tell the private equity firm, and, it's just it just takes the deal to a different dimension. So I think that's what's really been happening. Ashish can talk about the indirect transfer issue and how the government has done slight flip-flops and where we stand on indirect transfer, including the litigation process which is going on today.
Sure.
Thank you, Parul. That was very detailed. And Ashish, before you maybe jump in, let me make it a bit real for the folks listening in, right? Assume Inventors has shares in a company outside India, which they are valued from India, and Inventors has an investment in a company in India, in equity and in preference before 2017 and forth, and say we decide to buy it for a whopping $500 million, right? So $500 million, they invested 5 million, 100x return. We come to you, Ashish and Parul, both as very good friends, Ruthvik and I, to say, hey, we need to sign the deal in 24 hours. Give us a list of issues we need to break our head about, and please give us fair answers to all. And you could start on any end of the spectrum, right? From full tax withholding to insurance to indemnity to doing nothing and taking the rest, right? And across companies, across offshore, onshore, 2017 pre-post. Sorry, Ashish, didn't mean to interrupt.
No, sure, thanks. So I think on the indirect transfer front, I think we've seen a lot happening with from 2011 up to now. In 2011, it all started with the Bombay High Court giving a judgment that any indirect transfer of shares, which means basically that if a foreign company has an Indian subsidiary and the foreign company shares are being sold, specifically in the Vodafone case, then Vodafone was liable to pay tax. This went up to the Supreme Court, and then after a lengthy argument, the Supreme Court came out and said that no, this is not possible. India does not have the right to tax these. But a month later, after Supreme Court gave the verdict that indirect transfers are not taxable in India, the Finance Act 2012 came about, and it added the indirect transfer rule in the amendment. And at that point in time, because they wanted to tax Vodafone and all the others that were perhaps doing the same thing, they made it retrospective, and they made it from actually 1961. That is when the Income Tax Act actually came about. And this added to all of the confusion, and everybody started talking about this, lot of issues around the indirect transfer. Now, what becomes important to understand is, when does indirect transfer get triggered? At that point in time, because the Vodafone case, one argument was, and one thought was that because Vodafone held almost whole of the Indian entity, therefore that should be the trigger point for indirect transfer. But between 2012 and 2015, while all of this was still confusing, people didn't know about, the government actually did not provide any clarification as to when indirect transfer becomes applicable. Only in 2015 did they make it more clear that only if you held substantial assets in India would indirect transfer become applicable. And then they defined what substantial is. They said there is a small shareholder exemption. All of it then subsequently happened between 2015, 2016. And then, of course, we had Kane Energy, we had Vodafone, all of them using, going under the BIT that we have signed and going to the International Forum for an arbitration, resulting in very recently, as you must have all noted, that all of them winning the arbitrations there, and then wanting to take Indian assets abroad so that they could claim back the money that was paid to the tax department in India. That's when perhaps the government also realized that the retroactivity of the indirect transfer was not making sense, and then they came about with rules with respect to indirect transfer not being applicable to any transactions that took place before 28th of May of 2012. So on that front, definitely a positive move that the retroactivity was taken away. But on a going forward basis, I think a couple of issues, right? The first is, what about transactions that occurred between 2012 and 2015? What was the threshold for an indirect transfer to be triggered? What is the meaning of substantial? Would you go back and see that, since Hutchison held 100% of India, would that be the trigger for an indirect transfer to be triggered? Or would you look at a 50% test, which is the current test after 2015? Then could you say that the 2015 test actually, 2015 test actually is also retroactive in nature and therefore should apply from 2012? I think these are issues that we are still struggling with. There are litigations going on all these issues. For any transactions that took place between those 3 years, people are still trying to fight out what does substantial mean. And in that front, I think it becomes relevant for the government to step in and, tell them that, this 2015 substantial meaning would also be applicable for any transactions in those 3 years also. But till that time, we are still struggling with finding answers to those questions. Unfortunately, there is no Supreme Court ruling on the indirect transfer applicability on those 3 years. And also, of course, the larger question that is still pending as to whether the indirect transfer tax is actually valid and constitutional, because the Sanofi case that took place in the Punjab and Haryana High Court said that, one, that treaty relief would be available in case of an indirect transfer, but did not really rule on whether the constitutional validity of these provisions. So I think the Supreme Court still needs to answer those questions. And of course, the larger question, whether the indirect transfer tax would be applicable in case of a treaty relief that is available, especially in cases of Mauritius and Singapore, where we are seeing a number of exits taking place at the indirect transfer level. So that's about the history. Harshal, over to you.
Thank you. That was very insightful. Parul, over to you on our transaction. There's a $500 million deal, onshore, offshore. We want to sign tomorrow. Options available for us, for a willing buyer, willing seller, to get the deal.
Yeah, that's a tall task, first of all. But nonetheless, looking at the transaction size. So, there are 3 or 4 options that one can follow. And, let's just count out the ones which are not possible. The first one is to try to get, a ruling around the certainty of the tax withholding, which obviously, is forget about a day. It will take a few years for that ruling to come. The Advanced Ruling Authority was set up with this purpose, and many years ago the rulings used to come within a period of 6 months, which is anyway even pretty a big timeline for a transaction like this. But now with the transition happening to the BAR, the Board of Advanced Rulings, and the collegium which comprises of the board and the issues surrounding the constitution of the BAR, it seems unlikely that a BAR kind of a ruling may work in the transaction space. The other alternative is to go for a certificate, a no withholding tax certificate from tax authorities, and of course that again is time consuming. We have also seen a lot of reluctance by either of the 2 parties, mostly from the seller's perspective, to obtain a 197 certificate, even if their taxes, their facts are pretty strong, because no one really wants to go and go to the tax authority on their own. So therefore, and plus, even if there's a 197 certificate, while it may be useful for the withholder, the withholder is absolved from a withholding tax liability, but that does not lay rest to the assessment. This is only a preliminary kind of a certificate which is given. Tax authorities have the full right to recover taxes if they find due on the assessment. So that's again, that's something which can't be done. The easiest way, of course, which we have seen and which is what most people settle on, is on the tax indemnity part, where the negotiation is then primarily around, what should be the amount of tax indemnity, which should be agreed upon. What should be the period of the indemnity? And the period of indemnity, Harshal, now it's a very crucial and a controversial question, because, Ruthvik and yourself would have seen the periods for indemnity being, 7 years in the past deals which you have done. But there has been a change in the law, and the change in the law was to make it easier for for tax entities to come in, and the period was reduced to 4 years. But unfortunately, there has been an amendment also in the Act, and if the assessing officer, if the tax officer has certain information with him, including certain books of accounts or certain information regarding transaction details or expenses, then this period of 4 years can go up to 10 years. So actually, you're looking at increasing the period of indemnity from 7 years to 10 years. What used to be 7 now is actually now, could be 11. So the negotiation point would be around the period of indemnity, the amount of indemnity. If the period goes up, then the amount also goes up. That's what we've mostly seen in most of the cases. We've also seen where parties are unable to agree. We've seen amounts kept in tax escrows. And we've also seen challenges in release of the escrow, because when do you really see a tax certainty coming in? if you want certainty till the Supreme Court, or till the time that the period for appeals lapses, then we are really talking about a decade here, more than a decade. So tax escrow is not something which is liked by everyone, but we have seen tax escrows, and especially in an indirect transfer context. Ashish and I have been working on a matter where there is currently controversy around release of the tax escrow, on the transaction, the period of limitation having expired. So that's the other option. And of course, the last but not the least option, given the size that you're talking about, is that one agrees on the indemnity in order to close the transaction within a period of 24 hours, and then subsequently, go for insurance as a CS, as a condition subsequent. We had seen, a few years ago, insurance companies, they were done with their India limit, and insurance on India transactions was not easily available. But in the last couple of years, that seems to have spiked up. Most of these are grandfather transactions that we are seeing. And that's probably, the best way to go. There's a cost of doing the transaction. We are also aware that to get an insurance on an indirect transfer is not the easiest thing to do, because of the reasons which Ashish mentioned, that we right now, while we have an Azadi Bachao Andolan for direct transfers, but we do not have a Supreme Court case for indirect transfers. In fact, the Sanofi case was before the High Court. It was a positive case, and it was due to be heard at the Supreme Court. But because of the pullback on the retroactive amendment, Sanofi had withdrawn its case before the Supreme Court. So we are yet to see a Supreme Court ruling on the indirect transfer case. But if I were to close the deal in 24 hours, Harshal, I would just, negotiate on the indemnity and then, back it up with an insurance subsequently.
Got it. And which means it would have costs. Like, what would the costs, assuming we take 10% tax, we take a 3x indemnity to be simple for 7 years. 7 is not legal now. I know it's the average of 4 and 10, whatever bad math I have. So what would be the costs that each, the two of us would have to fork if we actually went for insurance?
So we've really seen this, differ from based on the facts of the transaction and of course the value. We've seen anything from 2% to 6%. If it's that wide. And I think in one solitary case, we also saw 10% of the tax amount. So, but that was like a really outlier in that sense. But I don't know if Ruthvik, you have experience on that, on what you've seen on insurance.
So we've seen in the same 2% to 5% range. So some of them have been closer to the 2 or 3% rather than the 5%. But that's roughly the range in which we've taken. And you rightly pointed out, even though there was a 24-hour deadline on you, and you came up with this insurance solution, in some of the transactions, even after a 2-month negotiation, we end up at the same with the same answer.
Okay, you're getting a bill right after the call, you and I.
Yeah. Yeah.
All righty. Now that we have the elephant, out of the room, again, indulge us, Parul, Ashish, in some of the nuances which take a look. For example, around title, which is 281. For example, on the seller filing tax return. For example, on this new clause that it's coming that they give us a certificate under some section that if they file, then our liability is only limited to interest, etc. Okay. If you could indulge us and give us more detail around, what are all the other nuances in addition to this elephant in the room that a buyer and the seller need to be aware of?
Yeah. So there are quite a few things to be done, and there are small things, compliances, check the box kind of things, any transaction which happens, one needs to look at what are of course, there's a capital gains tax. Everyone is aware of that. There is also Section 56 tax, which is on the purchaser. And there needs to be sufficient, there needs to be a sufficient comfort that, one is not triggering Section 56, which means there needs to be a valuation report in place for that. Section 56 is basically if the purchaser is getting shares at a value which is lower than the value, the fair market value, then the purchaser has to pay tax. It's a kind of a gift tax. This is, the value is the book value, but it's a kind of a drill down value. So we had an interesting case, in one of the situations where there was a distressed sale of an asset, but interestingly, the distressed sale also contained a road asset, many levels down, and that really, jumped up the 56 value. As well as, there's a section 50 CA also, which requires that the seller should pay tax at least at the fair market value. So there is valuation report which needs to be done. Of course, depending on whether the transaction is between resident and non-resident, there may be FEMA, reportings that may be required to be done. Between the buyer and seller, there are agreements with respect to, filing of tax returns, the seller not taking any adverse tax positions in the tax return, the seller is going to file a tax return, and so on and so forth. Those are there. Transactions, even between two non-residents, there's a 15 CACB form that needs to be filed and which needs to be submitted. And then for transactions which need remittances abroad, there is this whole thing about getting the TAN number, looking at the exchange rate, making sure that it's right to the last dollar for payment of the taxes in India. So I think primarily these are what all go into the transaction.
Yeah, and recently I heard, that if I have to pay Ruthvik like $500 million, I need to pay him 1 or 2% more, and he will deposit some tax on my behalf as a buyer, which sounds completely out of whack. Which literally sounds as a toll to put, like a toll to buy shares to the government. So indulge us and explain a bit about like what is this TCS? I thought it only applied on alcohol and not shares, but please tell us where we went wrong.
Yeah. So there is this tax collected at source. Actually, it was meant to apply, or actually it applies on goods. But there is a controversy as to whether goods include shares or not. And the view that was prevailing was that shares should not really be regarded as goods. I mean, there is a technical interpretation also to say, but in the context in which the section was drafted, that shares should not be regarded as goods. But then out came a clarification from the government stating that TCS will not apply to listed shares. So which means that they are considering shares to be goods, which means that TCS does need to apply. We've not really seen negotiation around the TCS part because, it's 1%, and so therefore it doesn't really make sense. But yes, that is something again which gets added to the transaction cost, and that's again something that needs to be done.
Thank you, Parul. Thank you. Like all of it seems our deal is not going to get over in 24 hours. There's so much detail, so many things to pin down. Switching gears, again to Ruthvik. We've currently looked at the foreign investor side, but let's dive deep a bit into the manager side, right? Both as a foreign manager, which is Mauritius, Singapore, and now as an Indian manager. Most of us have heard of the infamous, ICICI ruling, where it was alleged that carried interest to the Indian manager would be subject to service tax, which is 18% on the top line today, which means in addition to paying like 35 to 40% income tax, you pay 18%, which means your income tax and service tax rate in aggregate is northwards of 50%, right? So if you were to drill down and tell us top 3 items of challenges, pressure points, hot button items as an Indian manager, what would those be?
No, so this is a big issue, Harshal, which we are trying to grapple with. So just to give a little bit of history, our first two funds were Mauritius-based funds with foreign managers. Then we created an AIF, which is and are now currently we're Indian managers. And at least when we started off, it looked like there is becoming an Indian manager and investing money into India should be easier, but it turns out that it is actually far more complicated because of the issues that you point out. There's no clarity on. At the end of the day, all we see is work for that big pot of the gold, which comes at the end of many years in the form of carried interest, which is in terms of the profit share that you generate on the profits of your investment. The prevailing practice around the world is that this is a long-term capital gains tax because most of the time, carried interest is heavily back-ended and comes after 5-6 years of setting up your fund or sometimes even longer. So that's how it falls into the capital gains and becomes a long-term generally. But today, I think if there is this whole ICICI ruling which claims that it is going to be a service tax, that carried interest is a service that the manager is providing to the fund and hence pay that 18% GST on top of that. If that happens, then by definition, the income that we've generated from carry is a business income. And that could mean it would attract whatever 35% tax and maybe a surcharge on top of that. And we are looking at a 55-60% of your income being taxed out of it, which is a very, very unwelcoming move and will probably force many of the managers who have started to build India franchises with India domicile to again start looking outside and maybe just look at outside money and build franchises out of that, which is detrimental because that eliminates pretty much all Indian institutions and Indian capital to participate from this very, very fast growing and emerging asset class, which could be lucrative for this country.
Thank you. Ashish, moving, taking you from that, right? What are your views on carried interest across the world is taxed as capital gains? US has a 3-year holding period, and this is extremely detrimental to the stated objective of the government, which is to domicile more managers in India. Use domestic funds and domicile more managers. Why would you make it not attractive for domestic managers? One, and maybe you can use that to segue into the gift city regime, which is the latest kid on the block where a lot of fund managers are flocking to.
Sure. So I think going into your first question, and I'll let Parul take up the gift city question. On the point with respect to ICICI and the whole carry that has now become, subject to this discussion with respect to GST, I think it's also important to understand, while of course what the facts in ICICI were, but also to understand what the judges perhaps thought, what the judgment actually talks about in terms of saying why GST should be applicable to a carry. Now, interestingly and respectfully, the judgment comes out to say that the trust was actually providing asset management services to its investors, and which actually fell under the bracket of banking and other financial services, and therefore they were managing the funds of the investors. And taking this turn, they said that so whatever money is being paid to the manager actually becomes subject to a GST on the manager, which seems actually quite absurd, because at the one hand we have these trust principles and trust laws which say that it is the trustee who's managing it on behalf of the trust. It's trustee who's holding the assets on behalf of the trust. We have the beneficiaries, and then we say that the money that the trust has, the carry interest that is being paid, is actually something that was actually received by the trust or was earned by the trust as a service, which becomes quite absurd to think about it. And the second point being that the trust does not keep back any money, right? It pays it to the manager. So then how is it that any service fee could be paid by the trust on carry services that are provided by the manager? I think a couple of these points make the judgment quite questionable, if I may put it. And of course, that if you look at the facts with respect to how the whole judgment is worded and how whatever the documentation that ICICI was maintaining, I think it also gives us a good insight as to what not to be done, right? The way they had described the carry, it somehow gave the picture that, actually services were being provided. Now, these are important things that we need to consider while drafting our documentation also, so that tomorrow when we have a similar situation, we are able to provide justification that, the ICICI case does not apply to us for all of these reasons. We are not really providing services. This is basically my skin in the game, and this is how I have earned this money. I think this is important to understand and differentiate between what happened at ICICI, of course, on the facts, and also, of course, what the judgment really says. I'll ask Parul to take up the gift city question.
Yeah. So, and also I think, Harshal, on this carried interest issue, it's become such a sticky issue for the industry now. And, as Ruthvik could also appreciate that. There's been a talk of setting up a committee, at the Prime Minister's office, where some of these issues are going to be ironed out. So while the ICICI ruling can be distinguished based on facts and based on documents, based on legal principles, but The fact of the matter is that it is an industry issue. Is there going to be GST on management fee? Is there going to be tax on management fee as business income? It's just going to change the entire way an EIS is taxed, and there is absolutely no clarity on that. Industry is moving on the basis of, treating this as capital gain income. But tomorrow, if, there is one strike that comes, it's just going to, it's just going to have a big dent on, on the industry. Then why would anyone actually set up an onshore vehicle, for this purpose? GIFT City is something which, which is the government's pet project to onshore, offshore funds managed by Indian managers or even managed by offshore managers. It's a brilliant idea, and there is a lot of interest in GIFT City structures, rightly so. It removes a lot of complexities and issues which currently exist with jurisdictions like Mauritius, Singapore, others, etc. But when we combine regulatory and tax, tax, I think it's pretty clear. Actually, I'll come back on tax also for, it's been clear for till the last few days, but then the fund manager entity regulations got notified. So the intention of government has been very clear. It's a pass-through. It works just like a domestic AIF. Investors are, they don't have to file tax returns, etc. Even if the carry is treated as business income, there's a tax holiday, GST is exempt. So, you have sufficient safeguards. But when you combine with the regulatory framework, FEMA primarily, it's very difficult to set up a fund manager in GIFT City. You can't take Indian money. So that just, it just, again, it becomes a complex structure which may or may not work for, most people. To top it all, the SME regulations were notified a few days ago. And of course, now they need changes to the Income Tax Act, because for the same pass-through to apply, the Act also needs to change. Otherwise, how do you really get the pass-through? So I think some of these, issues are there, and maybe that's the reason why, we heard a lot of our clients and, investors in our in private equity funds asking, is GIFT City really there for the long term? I mean, what about frequent changes to the law? So I think that's on the GIFT City, not really going into a lot of detailing around it.
Thank you, Parul. Thank you. Thank you. Coming again to you. We heard a couple of points around Section 281, title risk, etc. If you could simplify it for the audience, like what does that mean? When I'm purchasing shares in a company for you and paying $500 million, why do I need to worry about your title to the shares vis-a-vis any other demands for you? So.
No, I think the reason for that is that, at least from the buyer's perspective, there is a lot of uncertainty. Sorry, Harshal, you're saying something? Sorry. So Harshal, so just to get to your question on, why all this 281 and all these uncertainty around that, when I look at, so Harshal, what I was trying to say was that, the reason why a lot of these complications come up is largely the buyers today are not getting comfort on what will happen to them if they do not withhold the right amount of taxes. So for example, if, the buyer is doing this $500 million of transaction, and today they don't withhold the right amount of taxes, or the TDS has not been withheld properly, the Indian government comes back after them, or the tax department could come back after them and make them liable for the taxes, the TDS not withheld, as well as put a penalty on that. And since there is uncertainty around all of these, what is the right amount, the buyers tend to take a very, very conservative approach. And their first opening position is that, hey, I want to withhold all the taxes. I don't care whether you have a treaty, you don't have a treaty. I don't care whether it was equity shares, CCPS shares. I'm going to withhold all the taxes. And that's where the negotiations start. That's the opening position from the acquirer's point of view. And then we go back and say, no, hey, wait, we make this investment in 2015. All of it is grandfathered. All of it is CCPS. And here's my tax advisor who's going to give you an opinion, who's going to give you a 281 certificate to give you the comfort that, hey, these shares are protected under the treaty. And then there are multiple views and multiple interpretations coming. And maybe a Parul or a Ashish can probably go into the technicalities or the details of why these multiple interpretations sometimes come up. But one of the big reasons is because in most companies, money is invested over a period of time at different valuations and different series of shares have been issued, which causes all these complications. But at the end of the day, I think the buyer wants to protect their liabilities, and that is the root cause of these negotiations and this unclarity around that. Now, I don't know if I fully answered your question, Harshal, but this is just to give a perspective of how these negotiations go forward, what the point or the interest, where the interests are aligned between the two parties.
Thank you, Ruthvik. That was very, very nice for a layperson to understand. And I mean, my network is on Vodafone, and I just got knocked off the WebEx for 30 seconds, but I got the gist of what you're saying. So, moving on, Parul and Ashish, if I were to respectively ask you the top 3 changes that you see, I mean, tax is more of, it always seems as if you're reading history. We're always talking last 5 years, last 10 years, last 20 years. Maybe, but if you were to take a sneak peek in the future and look at the next 5 years or 5 to 7 years, what would you say are the top, 3 items respectively, which could, change the way in which we look at tax in India?
Right. So I think, Harshal, according to me, certainty around carry taxation is really at the top of the list. I mean, at least where fund structures are concerned. Today, there is a lot of uncertainty around carry taxation. The second part would be certainty around, treaties. I mean, we don't need another Azadi Bachao Andolan for protecting treaty interests of, different investors. But there has to be some certainty around, availability of treaty benefits. And only when that certainty is there will transactions really get, completed in the 24-hour time frame that you're really talking about. According to me, these are the 2 big ticket items. There are, of course, a lot of smaller things which keep on happening, around capital gains taxation, how do you calculate the withholding taxes, etc. But I think these are the 2 main burning issues which we usually encounter in most of our transactions.
So I think I agree with Parul on the changes, and I think I'll just add maybe to something what Parul was saying. I think on the treaty front and the eligibility front, I think certainty is definitely what is required and the need of the hour. We are seeing, tax department questioning treaty eligibility day in, day out. And to be very honest, like Parul mentioned in the very beginning, today the law of the land is Azadi Bachao, and there has been no change to that. In fact, 4 years ago, there was another matter with Blackstone and Serco, where again the Punjab and Haryana High Court had ruled that it's Azadi which is going to rule the law, and Serco was almost like an Azadi 2.0, if I may put it that way. But I think with the amount of litigation that is going on and with whatever the tax department keeps bringing up with respect to beneficial ownerships, with respect to how there is no substance in these entities which are selling these shares, I think a positive view needs to be taken there by the government, and something concrete needs to be done so that there is more certainty with respect to this. And we have been entering into tax treaties from the last 20 years. I think that should be respected, and we should look at this positively instead of in the approach that we are taking today.
Thank you, Ashish. Ruthvik, maybe I'll do a quick rapid fire, and I know we have over 8 to 9 minutes. A reminder for everyone in the audience, feel free to put your questions in the Q&A box. But we recently heard rumbles of conversions of tax rates. So if you are a betting person, would you say that the non-resident tax is going to 20% or the resident tax is coming to 10%? Like, what's your immediate reaction?
I'm an optimist, as a VC, I'm born to be an optimist. So I would say it goes from 20% to 10%. But going by the history of what happens in this country, I could be proved wrong.
Maybe all of us go to the FM and settle in F15, which I think will be a great outcome for all of us. Second question, if if you were made FM, for a day, what would be, like the things that you would do to bring certainty again? At the same time, look, being an FM is great responsibility. You've got to run the treasury. You're the CFO of the country, right? I mean, you can't give all benefits and not have cash. So, what are the top, 2 or 3 things that you would do to kind of usher in, goodwill for folks like you and me who are, eternal optimists and investors?
No, I think it's certainty around taxation between resident, non-resident, which they've started moving in the right direction. Certainty around taxations on assets that are or investments that have been made, whether it's made from within India or outside India, whether the company has a headquarter outside, subsidiary India, or headquarter India, subsidiary outside. All of those things doesn't matter. But if there is a very, very clear cut that, hey, these are all investments and we should be treated them as capital gains, irrespective of what is happening. If that one single certainty comes in, I think it will solve a lot of the issues, because at the end of the day, these are productive assets generating employment and creating jobs in this country. And as a finance minister, I would think that creating jobs, creating employment should be my first priority, and any endeavor which leads towards that, I should bring clarity into that rather than trying to figure out how do I tax more out of it.
On that great note, I'm going to see if there are any Q&A, or maybe give a minute or two to the audience to see if there are questions for Ruthvik, Parul, Ashish, or me. I think I see one coming in from Abhijit Basu, saying, what is the root cause of this double-edged approach? Which is, why is Azadi Bachao without growth and oxymoron? Maybe Parul, if you want to take that. I mean, why this double-edged approach, a two-faced approach from the Indian, authorities?
So I think, two-faced approach, of course, we know what the law is. Now, there have also been instances where, taxpayers have set up entities. That entity is being controlled primarily from, by the parent. Now, when India and Mauritius have entered into a tax treaty, the tax treaty is to provide benefits to residents of Mauritius. While treaty shopping is legal, but this goes beyond treaty shopping. This is where the principles of, the lifting the corporate veil, etc., come in. Just by having a TRC and, setting up the entity in Mauritius, while that is protected, but in the event that the entity is actually completely controlled from outside Mauritius, then is that an entity which should really be eligible for treaty benefit? I think that's the question which tax authorities have been trying to raise. In fact, in most of the, the matters where we are involved on the litigation side, more often than not, the revenue brings up the argument that they are not arguing against Azadi Bachao. They are not challenging treaty shopping. But is there enough going on in that entity? Is that entity really taking its own decisions? That's what they're really challenging. It's a fine line. I mean, it's a very fine line. But that's really what it is. And, even though we say we have an Azadi Bachao, we have a Vodafone ruling also which fortifies Azadi Bachao Andolan. But at the end of the day, if there is a transaction which is a sham, and sham transaction is something which is, its true nature is different from the legal nature which is being presented. All of these are legal terms, but one has to look at a lot of fact finding, then the treaty benefit doesn't apply. That principle is also pretty clear. So I think that's the reason why they are also trying to, figure out whether treaty benefits should be available or not. At the same time, I agree that that does not really mean that, it's each and every case, no matter, if it's the more high profile it is, then the more likelihood there is of it getting picked up by tax authorities. That does not really warrant, every case does not really warrant a tax assessment.
All right, there is a question that I'll take from Saurabh. Maybe that's the last question. Also, forward-looking judgments, including one by a Canadian court in the case of Alta. I don't know, Parul or Ashish, if you cross the borders to look at Canadian case law, Canadian interject.
Sure.
But
So,
if you have, feel free to chime in.
sure. So I think what essentially the Canadian Supreme Court said was that, if there is a double taxation avoidance agreement between two countries and that is being used in a particular transaction, then you cannot really invoke GAR and say that, this is a sham. I think this is, of course, like the question mentions, a forward-looking judgment where the court respected that a deal is a deal, right? You cannot look beyond that and say that there is an anti-avoidance measure here. From an Indian perspective, I think I'd not say that we are long way from this, but I think we are getting there. I think with the number of judgments, with the understanding of the tax department of these judgments, I think we are crossing that barrier to understand that, treaty should be given importance to. We should understand that a deal is a deal. Of course, if there are situations where there is a clear sham or a colorable device, then they need to be handled differently. But every case cannot become a colorable device or a sham, right? I think that's the understanding that the tax department needs to somewhere get to, which I see that we are getting there. We are not there, but I'd not say that it's a long way off. I think that's how I'd put it.
Yeah, on that positive note, handing over to the person who's seen a lot of deals. But before I hand over to you, Mr. Mathur, again, thank you, Ruthvik. Thank you, Parul. Thank you, Ashish. It was great speaking over the last 15 minutes. Over to you, Mr. Mathur.
Thank you. Thank you so much.
Thank you, Harshal. Thank you, Ruthvik, as our honored guest. Thank you to the NDA lawyers. Appreciate very much. Now we are going to transition this program into the coffee corner. So everybody in the audience is invited to stay on and have an informal chat with our esteemed lawyers of NDA. And now the technical people who are supporting this event will automatically do the transfer. And I believe that the audience might see some button in the chat area, which if they press, they will automatically be transitioned to the coffee corner.